Well, I did it. I fired my public attorney today, and I claimed for mistrial. I said motion to mistrial and everything else. Hold on, let me grab my sheet. So here it's been 10 months. I had a Class D felony charge, and the judge told me I was going to get a jury trial. I was very advocate from the first day I got arrested with my first lawyer. Tried to contact them and give them a statement of what my end of it was, seeing that they never deposed me about anything that happened. And it'd be hard to defend somebody when you never even get their statement, I would think. So, again, that knocks the first lawyer out. But he quit on his own or quit showing up. I don't know. Actually, let me begin. The first court that I had was in Hancock, New York, and they actually said it wasn't because of a conflict of interest, and I don't understand the conflict of interest. What's the difference between one court and the other? The person that who charged me or accused me of these things doesn't work for the court. They work for the village or the town. Excuse me. I don't understand why the town court would have a problem charging one of its officers. It's not a representation. It's one of the officials. Why not be held in that court? And I've already got some conflict of interest and some, what do they call it? It's not a procedural errors, it's misconduct. Brady has been all over the road here. I've asked for information. The only thing that I have is this. And I know at some point in time my lawyer said something that they claimed it was 9/11, something about 9/11. And I don't have the statement of who she talked to about that. And that's a very important piece of information that I should have received as far as evidence and due process, and making sure I had everything for discovery over here 10 months at this point. Now, my last trial, they said some wonky stuff about it not being held in a federal court. And I knew it was weird, but I wasn't really sure. And I made sure I said something to the effect on the record. Don't know really what's going on. I don't do this professionally. I don't come here every day as a public attorney to do the particle slit experiment over and over again. You know, to get good and fast with something like Excel is like getting good and fast with something like bar practice or your MCATs, something along those lines. So, again, I just have the original statement, which is the only thing they have on me is, let's see here. I would probably have to say, George Scoville. If that's not abuse of power, I don't know what is. But I would have to kill somebody to get help. Can't just blame me and say check his post and stop him before he kills Neil and Jerry because they have it coming. I felt threatened by this Facebook post and was in fear for my life. Now again, this first off, just the statement in itself says I have an accuser. And I don't get to face this accuser because the state picked it up and decided to charge me with, what do we got here? Their new trial, which I just got today. The first time I received it, that just changed today, was committing the crime of attempted aggravated harassment. Attempted aggravated harassment. Degree of in violation of Penal Law 110 and 240.301A and or B. In that, the defendant, on or about November 19th, 2024, at 353 Sands Creek Road in the town of Hancock, New York, County, Delaware, State of New York, did knowingly, with intent to harass another person. The actor communicates anonymously or otherwise by telephone or computer or any other electronic means, or by mail or transmitting or delivering any other form of communication, a threat to cause physical harm or to unlawfully harm or the property of such person, nor a member of such persons, same family or household, as defined in subdivision 1 of section 530.11 of the criminal procedure law. And the actor knows the responsibility, should know, the actor knows or responsibly should know that such communications will cause such person to reasonably fear harm to such person, physical safety or property, or to the physical safety or property of the member of such person's same family or household. Now, again, it wasn't a member of my household. We're dealing with the A section here, where it's saying that I must have communicated somebody. I was privately posting on my Facebook page, and I had no friends. How would they have known to look at my page when I'm not friends with them, and I don't know anybody that would have willingly communicated with them or transmitted the message, nor do I have that in discovery? Not to mention the Law-Abiding Citizen Act I was saying, obviously, at this point in time, of these kinds of misconducts and procedural errors, I mean, come on. My statement makes perfect sense about somebody in that position that might be a little sociopathic to understand the consequences of what's coming against them, and deny me from protesting, deny me from going to town meetings, taking my property. And if it is not a felony any longer, how come they didn't tell me to take my guns back after I had to surrender them 11 months ago, or 10 months ago? And the original charge, actually that's not the original charge, committing the crime of attempted aggressive harassment in the second degree, a violation of the penalty. So it's a violation. I'd assume it's a misdemeanor of some kind, but the original, where'd she go? Oh, Susanna. Oh, yes. Making a terroristic threat, which is a felony complaint, was the piece of paper I got documented. I asked for the Class D felony. I asked for a jury trial. I asked for a trial. And this whole entire time, they've denied me my right to a trial, which I think is the Sixth Amendment. I know the Seventh will be the $20 grievances. It burns more gas to get up there to Walton than it does to have time in the court. It takes me physically longer to get there than the time I've had in court every time. Oh, not to mention the lawyer, what she gets paid to come out here and do these issues and not represent me. More like a power of attorney, because they're claiming I have a writ of incompetence, and I'm not incompetent. Nobody's ever claimed I'm incompetent. I don't have mental health issues. I don't have educational issues or a physical disability, so why wouldn't I be handed the information about my case? And from the get-go, how come they kept trying to do plea deals with me? 6 months OP restraining order, then no restraining order, and every single time, I never asked for those reductions. I just asked for the original trial so I could face my accusers on the stand in front of a jury of my peers. Now, they have abused a bunch of my civil liberties and my rights in this situation, and it's a delay of justice, or justice delayed. Bit of habeas corpus here. Where's the body? If all you have is this information, you couldn't go to trial with this, because that that's a First Amendment protected speech, and that you're not going to win that case, so now you have to transfer it over, so that way it's not in a jury trial, so you don't lose and catch a lawsuit about it by maintaining the same judge that allowed this to go on, told me I would have a jury trial, and then 10 months later denies that jury trial for this kind of nonsense. And so that's what I told him, and it really doesn't matter, because even if I claim that mistrial, mandamus, and cetera, which is mandamus is to an obligation for the judge to do what's demanded of him by this legal process, and cetera is a higher court. Those are both the President Trump move, good, bad, or indifferent. Brady, right? You got to pay attention to that stuff, because Brady's still going to go to jail. We learn the science and information, and it should be used to protect you in case of a situation like this. And much like mandamus and cetera, if these are the only two people, that district attorney's assistant, the judge, and my same public attorney, what's her name? Carolyn Morgan, and I've had her for 6 months out of the 7 months, 8 months maybe out of the whole entire trial now, and I asked her for a jury trial the entire time. So I mean, the judge still pushed it through. I claimed what I claimed, and then I plead the fifth. But again, he's still pushing it through. I'm going to represent myself, and what does it matter if there's a tyrannical force like that out there? I can't afford $40,000 for this charge when I'm innocent about the situation, and I can't ensure that there will be a payback because I went and loaned deep about what this is to later on win the case but not be able to pay it back because it's not the actual financial aspects of a fire aspect. And I wasn't. I just specifically asked to mistrial it. Let's take it back to arraignment, because you're allowed to mistrial at any point in time if you think that there's been a procedural grievance or if there's been misconduct of some kind. Now, I was trying very carefully not to mention, the misconduct, but I for sure understand this to be a procedural grievance. And so over that's what I am, but it doesn't matter if the judge is just going to push that stuff through. And why should I trust any of the attorneys that go to that place when the only one I've seen, I'm assuming, works in Delhi or Walton, which would serve to those courts frequently and would not want to get pinched by this issue, whether they wanted to or not. We are in the throes of the operation, so there's not a lot of getting out of it. I did get the number for the records, so at least I can get that and go through the records. I would like it to be an audio record instead of a specific written ledger, because it's a courtroom. First Amendment, you can't just take away my eyes and my ears and say that that's okay inside of the situation. And somebody's had to have said this before. But again, I don't want to run long on my issue. Catch you on the next one.